It takes 10 years to become current, and it takes, 9 years to process. That's good.
Welcome to Visa Vibes, the podcast where we break down U.S. immigration laws for international professionals and the employers that support them. I'm Emily Newman, managing partner at Reddy Newman Brown PC.
And I'm Stephen Brown. I'm also a partner here at Reddy Newman Brown PC. And today we're going to dive into one of the most emotional, misunderstood, confusing topics in business immigration. And we're going to try to do it in our normal podcast. And there's a whole book on it. And it is what happens when dependent children, we're going to focus on H4 and L2, turn 21. And we're going to talk about Child Status Protection Act, talk about options to consider, and what generally happens with these age-out kids, documented dreamers, they're also referred to, as they have a really good effort in Congress to try to reach protection.
Yeah, so what exactly do we mean by aging out? In U.S. immigration law, there are set definitions for every word that is important, and child is one of those words that has a set definition. For someone to be considered your child, they have to be under 21 and unmarried. So when you are applying for a work visa like an H-1B or an L, your child qualifies for a dependent visa, an H-4 or an L-2, as long as they are under 21 and unmarried. They are considered your child. Once they turn 21, they now become your son or daughter. They're no longer your child. They're now your son or daughter. Has a completely different definition, and they're completely cut off from that dependent visa for non-immigrant visas. And this also matters when you're applying for your green card, because your child can get the
Yes.
definition of child under 21 and not married, can get the green card with you, but your son or daughter who is over 21 or married cannot get the green card with you. So kids might have come here legally on an H-4 or an L-2, been here for years and years and years as their parents continue to extend. Their parents are in the green card process, but if the parents don't finish the green card process by the time the child turns 21, that child ages out of their current temporary visa and has to convert to something else, and they lose the green card eligibility on top of it.
Yeah, that's right. And this can happen even if the family's been here for a decade or longer and followed every rule, and that child really doesn't know any life. They came over at a young age. They've been American for non-immigration purposes their whole life. And the parents' green card is about to be approved, and they suddenly about to turn 21 and are no longer eligible. And it's a tough conversation we've had with parents that are facing this and what their options are or strategies, and it's not great. But this, we're going to talk through some of the good today, and we're going to focus on the green card side. Like Emily mentioned, there is no protection on the non-immigrant side. So if we're talking about H4, L2, E-dependents, there's no Child Status Protection Act as it relates to them. It's only on the green card side. There was a proposed regulation to help on the H4. It never went anywhere. But so we're going to focus solely on the green card side in this conversation today.
And this really has been a problem brewing for decades. Congress knew this was coming, especially as the visa backlog for green cards continued to grow and grow, particularly for India and China. So way back in 2002, they came up with a fix for it.
Yep.
And they called it the Child Status Protection Act, or CSPA. So it basically allows the child's age to be frozen for immigration purposes based on how long their parents' I-140 petition, I-526 petition for EB-5, or I-130 petition for family-based cases was pending.
Yeah, and look, I imagine there's also things with diversity visas and all that. We don't, if we're going to focus on those three, which are most common to our firm. So let's break it down. So CSPA allows you to subtract the processing time, how long the I-140, I-526, or I-130 was pending from your child's biological age at the date the visa becomes available, assuming the I-14526 or I-130 was approved, and that gives you their CSPA age. All right, so let's break this down. Okay, it's a formula. Um, so the CSPA age is the child's biological age when the visa became available, assuming the I-140 is already approved, minus the time the I-140 was pending. Okay, so if they are 21, it was 22, and it was pending for a year, we get them back down to 21. We can do the calculus there, but you cannot calculate CISPA until the underlying immigrant petition is approved. The I-140, I-130, I-526 is the immigrant visa petition, and a visa becomes available. Okay, so there's all these different ways that we have to look at CISPA, especially as the visa bulletin, is a roller coaster. It goes up, it goes down, it goes forwards, backwards, um, unavailable, completely changed with EP4. And so we have to look at this in a grand scheme of things with so many different factors. It's not just my kid's 22, do they qualify?
Yeah, and for people from these backlogged countries, they've got to be starting to think about this when their kids are 16, 15, even less than that, because they have to guess based on what their priority date is when we think it might become current, and will the child have aged out, be over 21 by that time, even if we take into account the time that petition was pending. And to make it a little more complicated, in 2023, the Biden administration modified how we determine whether an immigrant visa is available. So this started with the State Department splitting up the visa bulletin into the final action date chart and the filing date chart. And so CESPA was always calculated based on the final action date chart. Even though we created this extra chart back in 2015. And the Biden administration in 2023 said, you know what, we're going to let you, if you're in the US filing adjustment of status, we're going to let you go by the dates for filing chart if USCIS in that month lets you use the filing dates chart to file your 485. So just because your date is current in that date for filing chart, if USCIS says in that month, no, you have to go by the final action date chart, you don't get to use the dates for filing chart, which dates for filing is usually further ahead. So it makes the date become current sooner, reducing the amount of time that the child has to wait and reducing the potential to age out. So it's even more complicated.
Emily, I became a lawyer because I don't do math. Okay, and we're talking about equations here. But let's talk about some concrete examples here. Let me give you an example. So, I-140 for mom was pending for 6 months. Child is now 21 years old and 5 months, so they're not a child anymore. When the visa became available, the I-140 is now approved. Visa is available. They filed their I-485 using the date of filing chart, and that's the chart USCIS is using for that month. What's the situation?
So the child actual age, biological age, is 21 years, 5 months. They are not a child. But we first need to calculate their CESPA age. So we take their actual age and subtract the number of days that the I-140 was pending. So in this case, the child was 21 years, 5 months old, but the I-140 took 6 months to process. All of this is supposed to eliminate the burdens caused by government delay in the I-130, I-140, 526 processing. It doesn't eliminate delay caused by retrogression, where you're waiting for the green card to become available. So 21 years, 5 months old, subtract 6 months that the I-140 was pending. That means the child's CESPA age is 20 years, 11 months. They are now a child again, frozen in time. They can file the 485 even though they're actually over 21 physically at the time of filing the 485.
And before we get to our next example, you brought up something interesting. It's designed to get rid, to kind of recapture those inefficiencies in government processings. But we do see a built-in inefficiency sometimes that everybody's okay with when we talk about I-130.
Yeah.
There are times, if you go look at the I-130 processing times for children, that would qualify under, the family-based charts, um, they're long, but it's intentional. USCIS wants to, because those dates are so bad, they're so retrogress, they want to give as much CSPA age, time as you can. So if you file something, your I-130, and you're not current yet, and it takes 10 years to become current, and it takes 9 years to process. That's good. It's good to have that delay in that point. So for the most part, it can be helpful. It's a tactical decision you're going to have to make. Obviously, different on the employment based side where you want that I-140 to be approved to get all the benefits of having an approved I-130. What about consular processing, Emily? Does it work then too?
It does, but it's different. So when I mentioned that you can use the dates for filing charts, that does not apply to consular processing. So when you are calculating the CESPA age for a consular processing case, you can only go based on the date, the final action date chart. So there's fewer people that are going to qualify for CESPA in that case.
The Department of State hasn't adopted the same
No,
policy.
exactly. Yeah. So this 2023 policy change is only a USCIS policy, which they're under DHS. Department of State keeps their old policy, no changes there.
Okay.
To an extent, it makes sense because
Right.
they do it for people who qualify for adjustment of status because they're already here. They want to keep them here. Versus consular processing, they're usually outside the U.S. throughout the whole time, so they don't have those extra benefits, I guess.
Yeah, it makes sense.
So how does it work in a consular processing case? Let's say a child was born in 1998 and the I-140 got approved in 2009. Okay, great. Child was only 11 by the time the I-140 was approved. Plenty of time,
Right.
one would think. But the priority date is not current in 2009 when that I-140 was approved. Immigrant visa is unavailable. That means the child's age is not yet locked. So we can't calculate what their CESPA age is. Now they're 11, so we don't need CESPA yet,
Right.
but we don't know how long it's going to take. If it takes 15 years for the priority date to become current, they're out. But if it takes 10 years, maybe they might get there. So in this case, the priority date became current 9 years later in 2018. The child at this point is 20 years old. Now, National Visa Center gets involved, starts processing the consular processed green card. And as part of that, the child submits the DS-260, which is the immigrant visa application, when she's 20 years old. So she's before her 21st birthday. Submitting that DS-260 satisfies the requirement that someone seeks to acquire the green card within 1 year of immigrant visa availability. Because she did that before she turned 21, her age was locked. So we don't even need to worry about how long the I-140 was pending in this case because she qualified. However, so 2018, we start the green card process at the consulate. Various delays happen. They don't get scheduled for their green card interview until January 2025, 7 years later. The daughter is now 26, but guess what? She still qualifies because her age was locked because she was able to submit that form before she turned 21.
That's good. I mean, it's one of those instances where CISPA, we don't have to get into the nitty gritty, but it locks the age, which is good. Do we have any examples from this 2023 shift? Because like a lot of kids aged out,
Yeah.
right? And they would have otherwise been able to seek to acquire under CISPA had this always been the policy. So what did they do?
Yeah, so we had a number of cases that we helped on. So I have an example of one that I handled that it was just excruciating when she aged out because, you know, the dad was the main applicant. They filed the I-140, they filed the 485 even, and there was never any discussion of an age out possibility. And the problem was that by the time the final action date became current, because they filed under the filing date chart,
Uh,
when the final action date became current, she was 21 years, 5 months, and 4 days old.
uh,
But the I-140 was pending for a little while. It was pending for 4 months and 22 days. When we subtract that, she literally aged out by 11
oh my gosh.
days.
So
We get the 485 denied for her. So dad, mom, younger brother, they all get their green cards. Everyone's happy. Daughter gets a denial of the 485. Devastated.
and like not on a non-immigrant status either because she can't be on H4.
Right. Yeah. So she ends up going to Canada for a little while because this happened in maybe 2020, I think. Didn't change till
Right.
2023. So now when we look at the dates for filing chart and we recalculate it, it actually gave her 22 days to spare. So she ended up under her CSPA age being 20 years, 11 months, and 9 days old. She now qualifies. But how do we get her to qualify when the 485 has been denied 3 years ago? Well, thankfully, when they created this policy, they also said we will accept a motion to reopen the 485. Now, a motion to reopen has to be filed within 30 days of the decision. This decision happened 3 years ago. They thankfully said that the normal rule is you can file a motion to reopen late if there were extraordinary circumstances. And they clearly said in this policy that the policy change is the extraordinary circumstances. Therefore, we will accept a late file
That's good.
485 motion to reopen. So we filed it, got denied because it was filed late.
Because of course they don't talk to anybody.
Right. Like, I know it was filed, but I even told you I'm filing late, and this is why, because the policy didn't change till 3 years later. We got the ombudsman involved. They ended up reopening it, and then they issued a RFE for the medical, and they called her in for an interview. And then she finally got the green card approved. But
You know, interesting tidbit there. I mean, you think we've got the United States government, we've got immigration, and we want to like, you would think everybody's on the same page. But as we've seen over the years with that policy, with everything that's going on right now, with a lot of different things, components within the agency, within USCIS, don't talk to each other. They don't talk to the field offices. They get the kind of same policy update we do. Maybe they get it via email. And so there's not as much communication. And so sometimes it's not our fault as lawyers. It really is. You would think there's more competence involved from the federal government. One thing we see in some circumstances is concurrent filing of the I-140 and the 485 together. Yeah, especially when we could use the dates of filing. We see this a lot with EB1A porting over maybe the I-526 and the I-485 for EB5 that's current right now. So how CISPA works, we still can calculate based off of the time the I-140 is pending, but the age doesn't lock until the I-140, I-526 is approved, and they're using the chart, and you're current under that chart. So the date of filing with a final action date, you have to be current depending on what they use. So if we're talking about I-526, I-526E, great. Like that's current right now on both charts. But if we're talking about, let's say, in an EB1, 2, or 3, there's a difference between the two. And so we need it to be approved and current under that chart to lock the date in. And when we're talking about the concurrent filing, we have the seek to acquire within 1 year because you're filing the I-485. But sometimes priority dates retrogress during all this. We saw this a lot in, let's say this new policy was around in 2020. We saw a lot of examples where people were filing new I-140s to downgrade, upgrade, new companies, whatever. And then retrogression in 2022. So let's kind of walk through an example. So common example we saw, priority date is October 1, 2012. I-140, they get a new I-140. They've changed jobs over the times. Eventually, the new I-140 is approved in October of 2020. Filed their I-140. The child is 2003, so it turned 21 in 2024. Um, Visa now becomes current in February 2025 under the uh, charts here, but then it retrogresses in April of 2025. Let's go through the analysis, okay?
All right, so looking at the child's actual age, we can only calculate their CESPA age when the I-140 is approved and the priority date is current. So that would have been in February 2025. By that point, they were already 21 years and 4 months old. But the I-140 took 5 months to adjudicate, so we can subtract that and we get an age of 20 years and 11 months. So as long as, because in this case they already filed the 485, they sought to acquire within the 1 year. Therefore, the child did not age out. Their age was locked when they were 20 years, 11 months in that case. And even though after, so February 2025, the date becomes current, their age is locked, their I-140 is approved, the 485 is already pending. 2 months later in April, it retrogresses, does not impact them because their age is locked. So even if it takes 20 years for that date to become current again in February 2045, and this child is now 40 years old,
Yeah.
they still qualify.
Well, and again, this is designed to kind of solve this problem of they would otherwise qualify. What? So, I wanted to talk about some examples that we do. One thing you and I as a firm, value is practical. So, we wanted to talk about some practical impacts of aging out. Well, we're going to put CISPA aside for a minute. When these individuals age out, we see a few things that they can do. F1 student, most common, right? They're going to school already on their age 4, or they're about to turn 21. So now they're going to change status to F1.
Mm-hmm. Yeah, and then, potentially when they graduate, maybe they decide to get a PhD because they're super smart and maybe they can do an O1. So that by this point, they're completely, for their non-immigrant temporary status, they're completely away from their parent status. So even if under the green card they might qualify under CESPA and could eventually get the green card through the parents, for the non-immigrant status, they need to look at other options. So F1 is generally what we do when they turn 21. And then once they graduate, they get their OPT for 1 year, maybe 3 years if they have the STEM. Maybe they do a master's, maybe they do a PhD. Maybe now they qualify for an O1. If not, they have to go through the H-1B lottery, just like their parent probably did 15 years ago, and hope they get picked. Or in my example with the change in policy, the daughter actually went to work abroad for the dad's company for 1 year and then came back on an L1B until the policy changed and we were able to get her green card. Possibly an EB-5.
Yeah, this is something we've had a lot of strategic conversations with. Let's take, for example, a lot of this has happened with parents with like a 2014 priority date. They're, mom and dad are thinking, all right, we're going to get our green card soon, right? The next few years we will. But the child's going to age out. We want to pursue EB-5. We can pursue EB-5 because we want to protect our child, but we're worried about retrogression there. One thing we've seen is, they've gone through the source of funds analysis, they've got the funds, and then they gift that money to the child, the 800,000 or the 1.2 million. Then the child is able to pursue their own EB-5. Okay. Now we just add one step to the source of funds analysis to show that, okay, it was all lawfully acquired by mom and dad, and then a gift occurred. And then they can go about it their own way as the child. And this, again, not everybody's going to think EB-5 is a good route. But we've had this talk a lot with families who are exploring EB-5, like I said, 2013, 2014, 2015 priority dates, and mom and dad are like, we're going to get in here soon. We're going to protect the kid. And so they're looking at that. One that works is marrying for love. Okay, and I want to be very clear.
To a U.S. citizen.
To a U.S. citizen, marrying for love. Look, whatever you describe subscribe to as marriage, your faith or your personal beliefs, just don't get married just for a green card.
Yeah, for sure. And that leaves, one final option is what people call self-deporting, deciding that, the parents will stay here with their green card and the child who's no longer a child, now they're the son or daughter, they're going to go back to their home country. Or they're going to go pursue options in another country that have more favorable immigration rules. And then maybe the parents who are now green card holders can sponsor their child through the family based category.
Yeah, and there's groups out there that are really pushing on this. With this saving these individuals who have been here, been with their family. Really, it's kind of a messed up immigration system that's causing this problem. So, what do I want your takeaways to be as listeners is start planning early. We've seen the visa bulletin and really not having a good idea of what it's going to look like in the future. We've made some calculations before and had some guesses, but they're guesses. Um, as your child kind of approaches that 18 years old, start thinking about what are we going to do? I've talked to plenty of families, that are doing it younger. We have family friends that I'm friends with whose child is 10 years old, and they're starting to think, what are our options so we can look at this? Maybe an EB1, maybe this EB5 route, so we can prevent this. I don't think this needs to be keeping you up at night, but it is something to start thinking about, and then kind of track those I-140 processing times. So that for your case, you have that idea of what your CISPA age is going to be. Maybe there's strategic value in regular processing, and then watch the visa bulletin.
Yeah, and then for sure, make sure that the attorney who's handling your file is aware that you have a child at risk of aging out. Ask them to calculate their CISPA age or give some guidance on when we think the date might become current and what the calculations look like then based on how long the I-140 was pending. We had some situations where when we looked at the CISPA age, like they had filed their I-140 in premium processing a couple years ago and got it approved, great. But now that we're looking at the CISPA age, they were aging out by literally weeks. And we
Right.
thought, okay, what if we withdraw the approved I-140 and refile it in regular processing? So it takes a little bit longer. And then we use this new I-140 where we still have the old priority date
Yep.
to actually file the 485 because the CISPA age is based on the petition that is supporting the 485, which gets people confused sometimes because a lot of people have multiple I-140s approved, which they all have the same priority date, but one might be an EB3 and one might be an EB2. Those two I-140s were processed for different lengths of time, and the priority date might become current under EB3 before it does under EB2. So now we have to do the CISPA calculation under the EB3 category and see where we stand, do it again under the EB2 category and see where we stand, and then make a strategic decision of which one we want to move forward with. So there's definitely a lot to think about, a lot of moving parts to it. There's a lot of it that we cannot estimate because, again, we can never actually calculate the CISPA age until the petition is approved and the date becomes current.
Yeah, and so talk to your attorney. So a couple takeaways here. The 2023 policy helps a little bit. And I know we did a number of cases that people thought all hope was lost on their child's, their child's green card, and it worked out for them.
Yeah. And CISPA is old. It is 20 years old, 2 decades old. It didn't fix everything. It fixed a lot back then because retrogression wasn't nearly as bad, but it does not take into account retrogression unless maybe you're in the family-based case where the I-130 processing time is expanded on purpose to account for retrogression. They don't do that on the I-140 side. So if your child is turning 21, consider options like F1. Look into the EB5 option. Look into other independent green card options for them that might be needed.
Especially these kids are smarter than, with AI and everything. If they're going to school for that, maybe they can look at something, on their end, an EB1 maybe if they're depending on what they're doing. But aging out can be scary, and it's one of the worst conversations I think I have to have with families is we have this system that is not taking this into account. And so, but it's not hopeless. CISPA is there. And I think, proper legal planning and strategy can come up with the ideas on how to avoid problems or how to, cut them off before we even have to worry about the kid aging out. So, stay informed, stay protected, and keep up with the current guidance on how to keep your family secure.
All right, well, that's it for this week's Visa Vibes Rundown. Stay tuned. Next week, we'll be diving into a new topic. Don't forget to subscribe, like, follow, and share with anyone who's navigating this complex world of visas and immigration. And thanks for listening. We'll catch you next time.